Madam Chair, Honourable Indigenous brothers and sisters, in particular our relatives in the Pacific Caucus and the Indigenous peoples of this land, our Special Rapporteur James and I, and other delegates to the Permanent Forum. Madam Chair, remaining mindful of the ongoing impact of the doctrine of discovery on Indigenous peoples, the Māori Caucus recommends that the Permanent Forum 1. Recommend to the New Zealand Government that it carries out a comprehensive review of New Zealand's constitutional arrangements, including meaningful consideration of mechanisms for the recognition and protection of human and Indigenous rights, and the independent constitutional working group's findings and recommendations. 2. Strongly encourages the State Party to urgently implement transformation of New Zealand's constitutional arrangements, ensuring to obtain the free, prior and informed consent of Māori regarding any issues affecting them. 3. That the Permanent Forum acknowledges the intervention made today by the New Zealand Government delegation, in particular its statement that it is committed to ensuring the fulfilment of the rights of Indigenous peoples, and that it reaffirms its support for the Declaration, its principles and its aspirations. And 4, that in the interests of maintaining State Party integrity, the Permanent Forum enthusiastically challenges the New Zealand Government to align its aforementioned words of commitment and support with its conduct and performance by taking urgent and concrete action to fully implement the recommendations contained in the 2 New Zealand country reports of the Special Rapporteur. Madam Chair, last week saw the final day of a civil society march through New Zealand called the Aotearoa Not For Sale Hikoi. Initiated, led and hosted throughout the country by Māori peoples and communities, the Hikoi lasted over 2 weeks, was joined and supported by tens of thousands of New Zealanders, and was officially supported by numerous civil society organisations, a host of workers' union groups, and the Mana political party, which was born out of a commitment to providing an independent Māori voice in Parliament, amongst others, all of which represent a significant group of the Māori population. The Hikoi culminated with a rally on the steps of the New Zealand Parliament to demonstrate unprecedented opposition to a multitude of critical government-led social justice and environmental issues, including privatisation and the continued sale of our country's natural resources, land and public services to third-party foreign investors. The Trans-Pacific Partnership Trade Agreement that places unconstitutional limits on Aotearoa's economic sovereignty. The Food Bill, which violates the human right to food security of Indigenous peoples and citizens generally. Petroleum and minerals, mining, fracking and other extractive activities that threaten our environmental security, and attacks against workers' rights, to name but a few. These and other crimes against humanity must be halted and prevented with the constitutional entrenchment and effective enforcement in Aotearoa of our Indigenous and human rights. To close, Madam Chair, we have 2 questions for the Special Rapporteur. Sorry, 1 moment, my slides. My understanding is that New Zealand's commitment to the Declaration is severely constrained by Article 46 of the Declaration, which reflects the right of states to act as they deem necessary to maintain their territorial integrity or political unity, to recognise the rights of other non-Indigenous New Zealand citizens, and to meet the just and most compelling requirements of a democratic society. So our first question is, what strategic advice do you have, Professor Anaya, for Māori and indeed all Indigenous peoples in terms of implementing the Declaration despite the impact of Article 46, which appears to give states arguable justification for choosing not to fully implement the Declaration? And our second question, in regards to a new declaration, there's been some discussion at the session amongst Indigenous delegates about the notion of rights being somewhat foreign and contrary to our Indigenous values in terms of our natural relationship with the environment and with one another in this global human family of ours. The notion that feels more correct and appropriate to us is the notion of responsibility to protecting Mother Earth and to one another as brothers and sisters. So our second question is, do you see any practical value in the development of the internationally recognised instrument more aligned with our inherent nature as Indigenous peoples? For example, a declaration on the responsibilities of Indigenous peoples to be supported by states. Thank you, Madam Chair.
To take a human rights-based view of that provision, one that understands that provision in the context of an instrument that overall is to advance the recognition and application of Indigenous people's rights. On a more technical level, I might say that Article 46 does no more than simply restate pre-existing standards of international law related to the international human rights system. That's what lawyers like to call a savings clause in some respects. But it does not provide license for states or any other actors to run roughshod on their own whim over the rights that are affirmed in the Declaration that pertain to Indigenous peoples. While it might provide some level of limitation on the exercise of those rights, those limitations are no more than exist generally within the international human rights system for the exercise of all rights, and that are related to responsibilities of the rights holder. And so I would put a cast on Article 46, which sees it as related to the responsibilities of all, and use it indeed to read into the Declaration responsibilities of all, including Indigenous people, vis-a-vis the outside world, vis-a-vis other segments of humanity, and the natural world as well. Which is important regarding the second question, more specifically, to keep in mind that the Declaration is a product of a dialogue between Indigenous people, states, and other actors that took place over various years. It is many years. It is what I think is an intercultural expression of aspirations of Indigenous people. One that, while grounded in fundamental respect for Indigenous people's own worldview, necessarily speaks to the language of the broader international legal system, and hence uses the language of rights, necessarily building upon that tradition that is rooted within the contemporary international human rights system. Nonetheless, the spirit of the Declaration is to build upon Indigenous people's worldview and incorporate those worldview into it. And so I see the Declaration as implicitly incorporating the notion of responsibility as an expression. It is striking that throughout my work in various parts of the world, the issue of responsibility arises in connection with that being expressed by Indigenous leaders themselves, and that's extremely important. And I would urge Indigenous people themselves to come up with their own statements of responsibility. I think that would be extremely important. Indigenous people have that capacity to come up with their own codes, their own declarations, appropriate to their particular circumstances and worldviews. And those have authority. Those do have authority. So I would encourage Indigenous people to do just that, to articulate from their perspective this confluence of rights and responsibilities in a way that comes from Indigenous people's own worldview.